Hey there. On the latest episode of the SYCK Career Podcast, I'm really excited to have a former college buddy of mine who is now an employment lawyer. I personally have been impacted by termination and legal issues multiple times in my career. And I've also worked with lots of employees that have been impacted by termination or litigation. So I brought Jon onto this podcast to really talk about the perspective of a straight shooter, someone who's been on both sides of the game, on the employer side and the employee side. And I think you have a lot to learn from this episode. So dig in, listen to the episode, and if you like the SYCK Career Podcast, if you like this one, you like others, please rate and review the podcast. That really helps us build up listeners, make sure that people get the word out of how to own their career. So listen up, enjoy, and own your career. Welcome to another episode of the SYCK Career Podcast. Today, it is very unusual that I have a guest on here that I met before LinkedIn even existed.
It might have been before the internet even existed.
It's definitely true because we met I think the internet existed, but I don't think we had access to it at our university at Binghamton unless we went to the science library. But I met Jon at my university, Binghamton University, a small public university. We used to call it the Public Ivy, upstate New York. And Jon and I were on the same floor in my freshman year, his sophomore year. And that's where we met. And
Smith Hall, 2A.
I didn't even remember that. I remember I was in Smith. I remember I was in Ruse. I don't remember what year was what. A little too many drugs and alcohol during my tenure at Binghamton. But we met. We've remained in contact. And then for some reason, we have not been connected on LinkedIn, even though he has about 20,000 plus followers. I have 30,000 something followers. Our worlds did not collide on LinkedIn until about a month ago. We reconnected. And that is the power of loose connections, reconnecting and redeveloping those relationships. But the reason I brought Jon on is he is an employment attorney. He knows about how employment contracts work, how it impacts individuals, how companies can use it to their advantage, how employees can use it to their advantage. And I think it would be a great topic for people in the SYCK Career audience to listen to. So with that, I'm going to hand it over to Jon. Jon, tell the SYCK Career audience a little bit about who you are and what you do.
So I've been an employment attorney for over 25 years. I primarily represent businesses, both as I call myself an outside in-house counsel. So for businesses that don't have an in-house person or an in-house attorney, but have an in-house attorney, but they have wear kind of a more general practitioner hat, I bring the employment expertise to businesses as an outside in-house counsel, and then I litigate for businesses as well. I'd like to say that businesses that have enough foresight to talk to me beforehand might not need me to litigate for them, but those that don't have the foresight to talk to me beforehand and then make a decision that ends up blowing up into litigation, I'm there to bail them out on the back end too. And then I have two more niche practices as well. I think one we're going to talk about a little more today, which is my representation of executives, both on their way out and on their way into businesses and on their way out of businesses. And then I also have a niche representing craft breweries for not just their employment needs, but their corporate needs, their regulatory needs, with their licensing and everything else. So it is a practice that's definitely evolved over the years, but one that I very, very, very much enjoy.
Awesome. And before we get into the good stuff, do you have a favorite craft brew recommendation for the SYCK Career audience here? Something that you're digging nowadays?
I'm located in Northeast Ohio, so I will keep it somewhat local. But Fatheads is a local brew we have here. They do distribute, so if you're in Ohio or some surrounding states, you can probably get your hands on it. They have a beautiful beer hall and tap room not too far from actually where I live here in the Cleveland area. And they are famous for their IPAs. That's what they do best. And I was in the tap room last night enjoying a cold hopped IPA that I I'm enjoying it every chance I get because it won't be on tap forever. So
Nice. It's called Fatheads.
Fat Heads, yep.
Yep. Awesome. So I'm just drinking water here, but I think after this recording, I'm going to go
I'm in
grab an IPA.
I'm in my office, and we tend to frown on drinking during the workday. So
I work at home. I can do whatever the hell I want.
there
So,
you go.
so you've worked on both sides of the equation. You've worked on the corporate side, so corporations that are dealing with troubling employees or employee situation, and you also represent the employee. And you said on coming in to an organization, especially as an executive, because most people that come into a company have to sign a boilerplate contract. But I'm guessing some people at higher levels with executive power, executive privilege, can get opportunity to negotiate a contract on the inbound. Or am I wrong? Is it available to a lot more people, a lot more common folk?
No, I think you're generally correct. I think for higher level people, managers, senior level managers, executives, I think the stakes are higher. Their comp packages are higher. Their comp is often more involved. So you're looking at things like not just a salary, but bonus structures and equity grants and things like that. That we like to have, but we really need to have spelled out. I always tell clients on both sides of the equation, both the employer side and the employee side, you go into an employment relationship with the best of intentions, and every job I've taken, I've assumed I was going to retire from that company,
Mm-hmm.
and I've been at a few different law firms.
Yeah.
The one I'm at now, Wickens, Herzer, Panza, will be the one I retire from, by the way. But but you're not drafting the agreement for. I mean, you're drafting it to guide what happens during the employment relationship, but you're really drafting it to help guide what happens when that relationship ends, because things that are not spelled out in black and white in a clear and understandable document that both parties have the opportunity to review and understand and then sign, that's what leads to litigation, and that's ultimately what you're trying to avoid. I mean, I'm a litigator. It's what people pay me to do, but it's the worst way to resolve a dispute, like hands down. Like, no, I win because I get paid,
Right.
but nobody wins when you litigate. It's just it's a no-win situation for the litigants, because all you're doing is spending money, and it's money that you would otherwise have available to you to do other things with and pay your lawyer, right? No one likes spending time in courtrooms or deposition rooms, or lawyers' offices or whatever. So you are preparing the document to prepare for the what happens when the I hate to say inevitable, but I mean, how many people these days retire from the company from the first company they work for? You're preparing yourself for what happens when we have to when this relationship has to break up. And that's why it's important to make sure that you have everything spelled out in a clear and understandable fashion, in a contract at the outset of the employment relationship.
For most of my clients and most people that get a job maybe at Johnson and Johnson or get a job at Unilever or Google or Salesforce, they get a contract when they sign the offer. In the case of Google, it's a 20-page offer letter. It's really confusing. There's lots of different articles in there. One thing that is spelled out there in all caps, actually mentioned 2 times, is employment at will. So share with the audience of what employment at will means from the employee's perspective and the employer's perspective. But almost everybody in this country, outside of unions, and I don't know, maybe there's some exceptions, but aren't most people employed at will? And if so, explain what that means.
Most employees, 49 out of the 50 states are employment at will states. The only state that actually is not employment at will is Montana for some reason. Montana has a statute that requires a reason to fire an employee. But in the other 49 states, the other 49 states, employees in the private sector, non-union, so non-collectively bargained private sector businesses, are employees at will, which means you can be fired at any time for any reason, good, bad, or indifferent, as long as the reason isn't otherwise illegal, right? Discrimination is illegal. You can't discriminate against someone because of their race, sex, disability, age, whatever. That's still illegal. But absent an otherwise illegal reason, you can fire someone or they can quit. at any time for any at any time for any reason. That's what at will means. And you're right that most employment agreements are, unless you have a specific reason to employ someone for a defined period of time. Like, we know we're hiring this person to be our CFO, and we know that they're going to need 3 years to accomplish what we want them to accomplish during their initial tenure working for us. There might be a more defined period of employment. But in almost all cases, employment is, even when you have a contract, a written agreement, employment remains at will.
Right. And even before you actually start, on the start date, the company can retract the offer even before you start on day one.
Yeah, there's some exceptions to that. There's a legal doctrine we call promissory estoppel, which is a fancy way to say that if a company promises you something and you rely on that promise, and then you're harmed as a result of relying on that promise, you might be able to sue for damages that were caused by your detrimental reliance. So if you apply for a job, you are given a job offer, and then as a result of getting that job offer, you quit your other job, sell your house, and move across the country. You've relied on that offer to your detriment. And then before you even start, withdraw the offer, terminate the relationship. You actually might have a detrimental reliance claim, but you're right. As a default, as an at-will employee, you really have no right to anything.
So if the employer has the right to fire someone for any reason at any time outside of discrimination, are there any other exceptions? So I've seen situations, it's happened to me, where I have felt retaliated against. I raised a red flag about some poor behavior of a senior leader, and the senior leader wasn't happy that I raised the red flag. Very quickly thereafter, I was exited from the company. I got a nice exit package, but I went from promotion to firing in the matter of 4 months. So what if anything, are people protected on if they decide to poke the bear, decide to upset the apple cart, raise a red flag about something? Not necessarily, and we could talk a little bit about safety or something that has financial impact, but if someone just raises an issue that we have an issue that we're treating customers poorly, we don't like the way we're doing this, how, if at all, are people protected from retaliatory behavior from a superior or someone in charge?
They may not be. I mean, it really depends. The retaliation has to be tied to some conduct protected by law. So, I mean, whistleblowers are protected, but they're protected if there is a statute that gives them protection. So you are reporting financial improprieties. You are reporting that someone is discriminatory or sexually harassing someone. You're reporting safety concerns that might violate, OSHA. You are raising some issue that the law says we protect the rights of employees to report these issues, right? I'm not being paid correctly, things like that. If it's my manager's a jerk and I don't like the way he's treating people, there's no right, for example, to be protected from just general like bullying in the workplace, right? People have the right to be jerks if they want to be jerks. It's not a great employment practice, and you end up chasing off good employees, and you end up with a revolving door of people that makes it difficult to operate a business. So there's lots of reasons why we don't want our managers being just bullies, for example, but there's no law against it unless someone is bullying because of race, sex, religion,
right,
national origin, sexual orientation, age, disability, whatever, some status protected by law.
Yep. So I've managed lots of employees, and it's really hard for me as a manager to get rid of employees that are not performing well. I, as a manager, have had to put people on PIPs, performance improvement plans, performance enhancement plans. Different companies had different acronyms for it. Why do companies do that? Because I always found that it's very rare that an employee will go from a PIP to recovery, and a PIP is a performance improvement plan. So it's usually just a way that the company kind of documents things in a very arduous way.
Yeah, it's a CYA. You can blame the lawyers for the CYA. Yeah, so employment at will is the default. The reality is, because most of us belong to a protected class, we're a racial minority, we're an ethnic minority, we belong to a particular religion, we have a physical or mental disability, we're we're age 40 or over, right? We're old.
Yeah.
I'm 50. I don't even think of myself as, some days I think of myself as old, some days not. But we all belong to a protected class. And so every termination, even though employees are technically at will, every termination is still at risk for litigation if the individual can show that they were not treated, if they were treated differently than other similarly situated employees. So for that reason, employers like to have, and once the lawyers get involved, I mean, my worst case scenario is a client calls me up and says, we're having a problem with Jimmy. We want to fire Jimmy. Can we fire him? And I'm like, all right, well, what are the issues? And they tell me the issues, and it's, give me the demographics. Is he white? Is he black? How old is he? Any known disabilities, whatever. And they say whatever they say. And I said, let me see the personnel file. And I get the personnel file, and it's empty. Like, there's no written documentation of anything. And judges and juries like to see documentation. It's not enough for an employer to come in and if Jimmy then sues for whatever form of discrimination he's going to sue for, or he says, I complained about some guard that was removed from some piece of equipment, or I complained about some financial impropriety, or whatever claim Jimmy's going to come up with, I now need to prove that we had a legitimate non-discriminatory or non-retaliatory reason to fire him. And people like to see proof. Otherwise, it becomes he said, and now you've bought yourself a jury trial and all the expense and risk and exposure that goes along with that. So to answer your question, for that reason, we often like to use things like performance plans as whether you look at it as a last opportunity or the last step on pushing someone out the door, because it provides nice, typically objective criteria. You meet it, you don't meet it, and it gives you that extra level of comfort if you have to then defend. Because again, everything we do is to prepare for the worst case scenario, which is litigation. And so that document, if the person doesn't meet the objectives, gives you the comfort, gives you more comfort that you're going to be able to defend the termination. Assuming, of course, that the PIP itself wasn't deployed discriminatorily, right? Because you wanted to get rid of the black employee, so you put the black employee on a PIP, or the only employees in the company that have ever been given PIPs are black employees or females or older workers. That's a problem too. But assuming the bona fides of the PIP are actually bona fide, then that just gives you that added comfort level.
So as a lawyer, and most companies have lawyers either in-house or external, if they are going to get to the stage where they want to fire an employee, most lawyers, if they consult with them, will say, hey, get a documented record in here, like whether email or in a written file. Like, no one has files anymore, but like a digital file. Have some.
You'd be surprised.
So maybe there are.
I work with a lot of small businesses that aren't super sophisticated, even businesses that have like their own like HRIS, human resource information systems. A lot of times, like supervisors, like I'm always asking, like do your supervisors keep desk files, right? Do they have their own like personal files on employees that they just shove into a desk? And it happens way more often than you might think.
Most employers that are following the law or being represented by some legal support will document before someone is kicked out of the company often. I don't know if you know from your perspective, I, as a manager, have put probably 10 or 20 people on PIPs over the course of my career. It's never pleasant. It's a lot of work. HR requires me to do a lot of documentation of it. I've been put on a PIP when companies have tried to get rid of me twice, I think. And well, I've been terminated 5 times, but I think only with a PIP twice. But from my perspective, it's very rare that I see an employee turn things around once they get put on that PIP. I don't know if you have any perspective from the clients that you see once they put someone on a PIP, how often it actually turns around. Like, is a PIP really just a precursor to kick them out? Or because when it's delivered to the employee, they're like, oh, we're giving you this because we want to support you and give you all the resources that you need to succeed here. So I see it as just like a precursor to the exit. I don't know if you have a different perspective.
Slightly. I think it's both, really. I mean, employees are assets. Even marginal or poor performing employees are still assets. You have however much time you've invested in an individual employee, that's an investment. And the PIP is still a tool to be used to try to salvage that investment. So I don't think an employer, if you're giving an employee a PIP with the goal of the employee failing, then I don't think you're doing your job as an employer. I think you should give the employee the PIP and the support they need to succeed on the PIP. And they're going to succeed or fail based on their own performance. I think in most cases, employees who are on PIPs are put on PIPs because there is a performance issue, and that performance issue probably they should have gotten counseling and warnings and other things leading up to the PIP being deployed. And I think if they were going to show signs of improvement, they probably would have shown it already. So I think the reason why most employees fail on PIPs is because there is something that's just not that they're bad employees. There's just something in that position or that organization that's not working for them, that is causing them not to succeed in that position or in that particular organization. And either through the employer's choice or their choice or their doing, they already have one foot out the door anyway. And so the PIP kind of pushes that other foot out, but that shouldn't be the goal. The goal should be, we have 3 years invested in this worker. We would like to recoup that investment if we can. And so we would like this person to succeed. We're going to give them attainable goals that they should be able to meet if they are going to be a productive worker for our business. We're going to have periodic check-ins. We're going to get them whatever help we think that they need to succeed and come off this PIP on the other side and remain employed. But the reality is that just most employees don't, because there's a reason why they're on the PIP in the first place.
And from the employer side, it's a pain in the ass to put someone on a PIP, or at least as a manager's side. And I've done it a number of times. It's a pain in the ass to document everything, follow up, meet with HR, sometimes meet with legal. It's a pain in the ass from the manager. So if they're going to that extent where they're documenting this, I just fundamentally think it's a very rare time that someone can turn things around on that team. I've seen people leave the team and be able to survive.
No, I think you're 100% correct. It's a pain for the company, the managers, HR. It's a pain for the individual. Yeah. My view, right? If I'm given a PIP and I say, you have 90 days to turn it around, I'm thinking I have 90 days to find a new job. That's my thought, right?
That's your thought. It's not always conveyed like that. And I've spoken to lots of people. I've spoken to employees. I've spoken to people that think, because managers sometimes are not comfortable being direct. So they are like, yeah, we're going to help support you here. So they talk one way and they don't follow up. So I think people just need to be concerned if they get a PIP, that they should assume it's most likely not going to turn out well on that team for that leader, because there's too much inertia. So in the case, from the employee's perspective, I always advise, hey, ideally before you get the PIP, and to your point, John, you will usually get a lot of verbal feedback ahead of time that the manager is trying to avoid that PIP in the first place. So you should have the writing on the wall ahead of time. But once you get this PIP and they say 30 days, 60 days, 90 days, whatever the company's policy is to turn the ship around, you as an employee should be like, I should probably focus as much, if not more, of my attention on my exit strategy than investing in trying to accomplish what is laid out here. Unless you authentically think that this is going to turn around for you and your boss is in your corner, my default is assume you're going out, focus more of your effort on either internal within, like somewhere else on the team, or out of the company. What do you think about that suggestion for, like, in terms of how to focus your prioritization?
I think that's spot on, because the worst case scenario is you get to the end of that 60, 90, 120 days, whatever the PIP period is. You've not met the metrics. you're terminated and you're given a 2-week, 2-week severance package or whatever, or worst case, like no severance package, right? They're just, we tried, didn't work. Sorry, you're unemployed. And now now you have no source of income, right? And so you need to prepare for the worst case scenario, which is in 90 days, I am going to be unemployed. And so you should be using that time to make sure that that doesn't happen.
And often a precursor to the PIP is a poor performance review. So I don't know how many of the companies that you deal with are large organizations that do performance management and calibration and give people a rating, usually on a 5-point scale: awesome, semi-awesome, average, mediocre, shitty, some euphemism of that. It's usually 5 ratings. Almost every company I've been at, it's been like 5 ratings. Amex does 6 ratings, but whatever. If you get a low rating, I've been at a lot of companies that sometimes it's a default. If you get in that bottom rating, the shitty rating, the 5 percentile or the 10 percentile, it's almost a default for a PIP. Or if you get that performance rating multiple cycles in a row, then it's almost an automatic PIP. I don't know if you've seen that also, because I'm trying to give people the insight of when to start seeing the yellow flag, so that they don't need to wait until the red flag, until their internet is cut off and they're shown out the door.
Yeah, that's for sure a yellow flag. And a lot of people, because you take this stuff, people take it personally, and they're like, well, this isn't fair. I'm not being rated correctly. This is not a fair evaluation. But at the end of the day, for the employee, like that's not your decision to make. Like, that's the company's prerogative. It's a manager's prerogative to rate you how they want to rate you. And again, it doesn't mean you're a bad person. It doesn't mean you're a bad employee. It means that you, whatever position you're in, whatever team you're on, whatever organization you're working for, it's not the right one for you, right? And so you should absolutely look at those ones and twos as a pretty significant indication that your tenure at that organization is not going to be very long.
Although 1s and 2s with a high rating at Amex, so it depends on the company. Well, 3s and 4s are low, but like whatever, like whatever the shitty number is, you don't want to be in the shitty number.
If you're at the bottom, and there's some companies that are I don't know if they still do, but General Electric used to cut the bottom 20% every year. They would just say the bottom 20% of employees in their numerical rating system, like, you're gone, and they would just bring in new heads to replace them.
Yeah, Amazon does things like that too, I think at the 6th percentile. But yeah, different companies have different rules. So I've also dealt with employees that once I gave them a bad rating and she knew a PIP was coming, the next day, right after I gave her a bad rating, she went on sick leave. And I think she's actually still on sick leave. And I've been out of this company. I won't say the name of the company, but I've been out of this company for several years. She may not still be on sick leave. I actually should check. But she was on sick leave for at least a year while I was still there. She would change it from, she would have to get doctor's notes. She would have to get FMLA. She'd have to go through these different processes. And it made it really damn hard for me as a manager to get rid of her. So how can people protect themselves and get themselves extra time? Because she was still getting paid by the company. She was actually still getting her equity vesting while she was out. She was still, I think, actually getting bonuses. I'm not sure about that, but she was doing that, I saw, as a protective move. And I was like, oh, that's brilliant. It's a pain in the ass for me, because that headcount is frozen.
I would say if I was ranking questions I get from clients the most, that's probably at the top of the list of calls I get from clients is, we want to fire this employee. They just went out on sick leave. What do we do? If they've worked for the organization long enough or the company's big enough, that sick leave is probably protected by FMLA, which puts that individual in a protected class. FMLA or no FMLA, the underlying issue that's causing the employee to be out is probably going to be the definition of disability under the ADA is so broad that it's probably going to be a protected disability. There's ERISA concerns. ERISA is the federal statute that governs benefits, including health benefits. There might be ERISA retaliation concerns because they're using benefits, and maybe there's an ERISA issue there. There's all kinds of things that could protect that employee from a termination in that situation. And a lot of poor performing employees think, well, I see the writing on the wall. I just got my performance review. It's a 1 or a 5 or whatever. I'm at the bottom. and I've had a bunch of warnings, and I think I'm going to get fired. So I'm going to go out on a medical leave. I have, I have severe anxiety. I'm going to, and I don't want to downplay people with, with mental health issues, but, I have severe anxiety. There's doctors that'll write notes for anything. I'm going to get this doctor's note. Now I'm protected. They can't get rid of me because I have this protected medical issue. And they're correct to some degree, and they're wrong to some degree. And it really depends on how much risk a business wants to bite off. Because in that situation, sometimes there's a plaintiff's lawyer talking in the employee's ear to say, we need to figure out a way to protect your job or create a claim for you, because right now we don't see one for you, but we want to try and create a way for you to maybe sue the company when you're fired. So maybe there's a plaintiff's lawyer talking in the employee's ear. Maybe the employee just Googled, how do I save my job? And it's what you need to, come up with a medical issue. So the performance issues were the performance issues before the person went on medical leave. What I want to see, if I'm counseling a business in that situation to pull the trigger on a termination on the heels of a medical leave, I want to see that decision process kind of well down the road to a final decision, before the employee gave notice of a medical leave. If there's just preliminary discussions, if there's no discussions at all, then it starts to look like retaliation. If I can show that, like, HR was meeting with the frontline manager who was meeting with senior management, and they were well down the path of reaching a decision to fire this employee, it would have happened medical leave or no medical leave, and the medical leave just happened, the request for the medical leave just happened to come in at the 11th hour. I mean, I'm going to advise the company, no termination is 100% risk-free, and this one might be, if we're using kind of green, yellow, red on a caution scale, this might be a yellow, not a green, because of the medical leave. But you have a legitimate reason to let this person go, and but for the medical leave, they would have been fired in the next week anyway. And so understand that you might be paying me to come in and defend this lawsuit on the back end. So you got to decide, do you want to let yourself be held hostage by this employee with this issue that came up at the 11th hour, or do you want to execute the decision you had already made, understanding that we might end up in tears of litigation and what that might cost.
Yep. So people are on PIPs, or even the precursor to the PIP. And I'm not telling people to abuse the process here, but I've dealt with clients where they just have a really difficult situation, but people are employed at will, so they could have a difficult boss who doesn't like you, whatever reason. There could be a reorg, they want to push you out. Would it be bad advice for me to advise my clients to say, hey, if you're dealing with some stress here, you may want to see a doctor. You may want to take some time off. You may want to figure things out. Is that bad advice to give an employee to help protect? Is there any downside? Because theoretically, they're not supposed to be retaliated on because of that.
Yeah, I mean, the downside is that they're going to lose their job, but they might lose their job anyway. So understanding, that's the downside. Risk to the employee is they might put the request for the medical leave, it might get denied. Now they have unexcused absences and they're going to get terminated, but they're down that road anyway. So there might not be a lot of downside for the individual. You might, depending on how aggressive the business wants to be, you might have to turn over some medical records. You might have to go for a second opinion to a doctor of the business's choice if they doubt the bonus. If you get someone without a documented history, as far as the business knows, of mental health issues, then comes with a note that says, Jimmy has, an anxiety disorder and needs a month off from work, and he's under my care, and this is all new to the business. The business might say, well, this timing looks really fishy to us, and they might press for some documentation to help support that underlying medical issue and the need for the leave. They might send the individual for a second opinion. So there might be some additional burden to the individual. But in terms of employment risk, there's probably not a lot, because they're probably their worst case is they're fired, and that might be the path they're headed
Right.
down anyway.
Exactly. What else can people? So if individuals are employed at will, and they can get fired for any reason at any time, except for discrimination or except for anything legally supporting them, um, that also means that they can leave for any reason at any time. Is there anything legally binding that people need to give 2 weeks notice?
No, no. The 13th Amendment got rid of that. So, yeah, we don't have slavery or indentured servitude anymore. You can't keep someone. You can't keep someone at a job. What you can do, what businesses can do, if they want a 2-week notice period from an employee, is they can do things like, we will. They can condition like payouts of uh, unused paid time
Mm-hmm.
off on giving a notice period. So we will pay you out your unused PTO at the end of employment, provided if you leave of your own choice, provided that you give us that you at least offers the opportunity of a 2-week notice period. So I've seen businesses do that, and I've written policies that say that. But otherwise, there is nothing. If you want to leave, you're free to leave. There's nothing a business can do to chain you to your desk and stop you from walking out the door.
So if you as an employee can get fired at any time for any reason, um, why and you're always at that risk, and there's not too much. Well, I guess if you perform well, if you're in good um, if you're in good perspective from your boss, you have a good relationship with your boss, the business is doing well, the odds are less that you will get fired. But anyone can get fired for any reason, and there are RIFs, like reduction in forces, and like more surgical PIPs. But if anyone can get fired for any reason at any time, why should people not always be open to looking for other opportunities and consider leaving at any time for any reason? There could be reasons that they love their company, awesome. But if you know that there's no loyalty from the company to you,
I tell people all the time, like, you don't owe your employer anything. You owe them nothing. They would, in a heartbeat, if they had a reason to do so, let you go. Right? It could be an economic downturn. It could be a reorg. It could be you get a new boss or a new supervisor who doesn't like you, and you're gone the next day. They don't owe you any. So I tell people all the time, don't feel that you owe them to stay, because they wouldn't hesitate to let you go if they had to. I'm here at my current firm, and I wasn't looking when I left my old firm. I just took a call from a recruiter, and was open to a conversation, because I was curious as to what opportunities are out there. And 6 weeks later, I was sitting in this office. So people should be open to exploring opportunities always, because A, you never know when that shoe's going to drop. B, there is no downside to networking. And C, you never know what opportunities are out there unless you are open to learning about them.
awesome, John. And we're running a little low on time. I have I have two more questions as I wrap up. If at all, should an employee reach out to an employment lawyer? Like, in what situation should they do it? And like, what are the signals? What are the warning signs? And how early in a process, if they think that there's something wrong with discrimination? Outside of discrimination, are there any other reasons to reach out to an employment lawyer?
Yeah, I mean, if you see, inappropriate conduct in the workplace, discrimination, if you see inappropriate conduct in the workplace, if you're not being paid correctly, there's all kind of reasons why you should. If your spidey sense goes off, it's not a terrible idea to pick up the phone and call an attorney just to bounce off them. Like, should I be worried here? Do I have concerns? What should I be doing? What should I be thinking about? What should I be doing? Never, really never a bad idea. I don't think it's ever too early. The worst thing a lawyer is going to tell you after a 30-minute conversation is, it's not that I can do for you, or maybe give you some thoughts and to take back to things to think about, or things to maybe start documenting things, or whatever information or advice they give you. But I don't think, if your spidey sense says, should I be contacting a lawyer, the answer is probably yes.
Awesome. So my last two questions. One, like, you've given lots of great advice for my audience. If you had to leave my ambitious professionals out there that are listening to this podcast one last piece of SYCK career advice to help support their growth, protect their careers, accelerate their careers. What advice do you have for them?
I would say don't take anything personally. I think we get too hung up in our careers with every bit of performance feedback we get being like, if it's negative, as being soul crushing, like it's a reflection of you as a human being. And it's not. There's lots of reasons you don't gel with your manager. Like, it happens. Like, I've worked with lots of people I haven't gelled with. Like, it happens. It's not a reflection of who you are as a person. It might be a reflection of how that particular manager views you in that particular role at that organization at that time. But it's not a reflection of you. And so the answer is, rather than dwell on the negative, is to flip it into a positive, to either decide this is what I need to work on and improve, or say I'm never going to improve it here, and then look for that next opportunity.
Great point. And last question I have, where can people follow you, and where can they reach out to you if they need some help with either on their way in from an employment contract perspective or their way out to protect their tushes?
Yeah, I'm not hard to find. You can literally Google Jon Hyman employment lawyer, and there I am all over the place. But you can find me my law firm's website, Wickens Herzer Panza, which is wickenslaw.com, WICKENS law.com. You can find me on LinkedIn at Jonathan Hyman, because someone stole Jon Hyman before I could get it. You can find me on Twitter at Jon Hyman. I have a daily blog I've been writing for 15 years, the Ohio Employer Law blog. It does kind of come from an employer's perspective, but I'm not gentle with employers that I think are doing crappy things. And so I think individuals, employees would find a lot of value there as well.
Awesome, Jon. Well, I appreciate the time. I appreciate the fact that we reconnected after probably a couple decades, maybe 3 decades since college. And thanks for sharing all your advice with the SYCK career audience here.
Awesome to be here. I love the internet. It was so good to reconnect with you.
It's a power. Thank God for Al Gore, right? If he didn't invent the internet, none of us would have been connected anymore.
There you go.
Awesome, Jon. Thanks a lot.
That wraps up another remarkable episode of the SYCK Career Podcast with Alan Stein. Check out past episodes and other resources on the website. That's syckpodcast.com, and it's SYCK. Alan, tell the audience about the newsletter they can sign up for.
The newsletter rocks. Check out the accelerator, XLR8R. You will get great tips about your career. You'll get honest insights. You'll get the occasional pet picture, and you will learn how to take proactive control and take charge of your career.
Very good. Very good. That's syckpodcast.com, SYCK. For your host, Alan Stein, I'm Russ Reba, and we hope you've enjoyed today's episode. You are going to love the next one.